The court will call the case of Capital One NA versus Cartessa Brown, 24C-1552.
Good afternoon, Your Honor. Jeffrey Beers, P41693, on behalf of plaintiff Capital One.
Thank you. Is
Hello?
Ms. Cartessa Brown, please state your name.
Yes, this is Cartessa Brown.
Thank you. All right, this matter was adjourned from the last court date we were here, which was January the 16th, in order for the plaintiff to send a copy of all of the billing statements to Ms. Brown, and there was 30 days for discovery through February the 16th, and bringing us back here today to hear the motion for summary disposition. Ms. Brown, have you received the documentation you were requesting?
Yes, but I didn't receive all of the documentation. When I was looking at the documentation, I noticed that the billing date was from May 28, 2022 to June 26, 2022, and it already had a balance of $2,000 and something. The balance was $2,690.70, so I didn't receive all of the billing dates as requested. Also, like I was telling them, the reason why I was asking for that is because my ex had access to that card. And I also contacted Yahoo because at one point in time I had to pay for a subscription to get back into my Yahoo account because he took over all my accounts. And then they told me that I needed to get a subpoena to get that information.
Thank you.
Because it was so old.
Well, I can tell you now that they are not responsible because your ex has the card, ma'am. That's not going to be their responsibility. But Mr. Beers, response, please.
Your Honor, we did send her 72 pages of statements the last 2 years worth. There's been no written response to our motion for summary, no affidavit filed by the defendant in response to our affidavit.
Can you please speak up some? I don't think she can hear you because I barely can.
Your Honor, we sent her 72 pages of monthly statements going back to the most recent 2 years. We did not receive any written response to our motion for summary or any affidavit filed by the defendant to rebut our affidavit or any documentary evidence.
I'm not actually getting into the motion yet. I'm addressing her concern regarding not getting all of the statements.
Okay. We did send her the last 2 years worth of statements, approximately 72 pages.
Well, it didn't start at the first statement, the balance starts off at $2,600 and some change. But that statement that you sent me, it was only $652 charged on that. So that wasn't the first statement. I thought I was getting the statements to verify the purchases that were on the account.
Our response to that would be that payments were made in response to these monthly statements, which is a confession of the accuracy of the statement and the amount billed in the statement.
And my response is still the same. I do understand that the judge said that that you guys are not responsible because my ex had a card, but as I told you the first time, I was in an abusive relationship, and he had access to my bank account as well, along with my emails, everything. And I wasn't even seeing the mail at the time because that's how controlling he was. So he was paying sometimes up until we broke up. And I also told you when we met that I called several times. I called Capital One several times to ask them to close the account, which they refused because they said that it had a balance on the account. And so that's why I asked for a copy, because I'm not confirming or denying the charges, but I was in an abusive, controlling relationship. And so, yeah, it was paid until it wasn't paid. And like I said, I called I guess I got to get a subpoena. Maybe I have to do the subpoena myself for Yahoo. But they verified the time when I was able to get back into my Yahoo account because he was controlling all of that. And that was, like I said, April 24th, 2023.
All right, thank you, Ms. Brown. I believe that what Mr. Bears is saying is that the law does not require that he provide you with those additional statements once payments have been made. It is not his responsibility, and the law doesn't require that he actually show you each of the statements and that the account is considered affirmed, whether you paid it. And I'm sorry to hear about your situation, but that does not affect the person who made the lending. That would be between you and the X, not between the capital one and the X, I believe is what his argument is. Is that correct, sir?
Yes, Your Honor.
Well, that's fine. I'm not, disputing it. That's just what was said. But, that's fine. I
Ask,
understand now.
now we can move on to the motion for summary disposition. Ma'am, have you had a chance to review that motion and determine if you have any additional arguments that you want to make regarding that, or if you want to try to work with Mr. Bears to work out this particular matter?
I can try to work with him, but I mean, I can't afford to pay anything right now. So, I mean, I could try to work out with him, but I don't know.
If you can't afford to pay anything and you don't think that you guys can reach an agreement, I can make my ruling on the motion and then they'll end up with the judgment and that'll be on your record, just so you know. So it's your choice if you want me to move forward at this time. You haven't filed a written response, which is what he is arguing. I heard him start that argument as to the motion for summary disposition. You haven't filed a written response or an affidavit as required by the law. So therefore, I'm sorry about that. Do I still have time to file an affidavit or a written response, or that's expired because of today? Because of today, it was actually, I gave you additional time from January until today, and there's been no response. I took your verbal response last time. So, today.
Yeah, I'm sorry, I didn't know.
Okay.
I didn't know that I was supposed to do a written response. I thought coming to court was like, that's when you do the response. I didn't know. So I apologize for that.
So, I've been accepting your verbal arguments. But if you want to try to talk to him, I'll give you that chance. And you can come back and let me know whether you guys have reached any agreement or not. And I can hear the motion afterwards, or we can just go forward with the motion right now. What would you prefer?
To talk to him.
All right. Mr. Beers, I'll put you two in a breakout room and see if you can reach any agreements. All right, the court will recall the matter of Capital One NA versus Cartessa Brown, 24C 1552.
Your Honor, we had an opportunity to speak in breakout. We agreed to a consent judgment in the amount of $4,274.48, which is damages of $4,032.43, court costs of $242.05, for a total amount of $4,274.48, with the additional order that judgment shall be paid for the $10 down payment on March 25th, 2025, increasing to $90 per month starting April 25th, 2025 at 0% interest. And we're proposing to submit that under 7-day rule.
All right, you said increasing to $90 on what day?
April 25th.
April 25th. It's very hard to hear you, Mr. Beers, so that's a part of what's going on. The total consent is just the total number, please.
$4,274.48.
Okay. Ms. Brown, is that true? You're going to enter into a consent judgment for $4,274.48?
Yes.
And you're gonna pay $10 down,
Yes.
and then you're going to increase that amount to $90 on April 25th of 2025?
Yes.
Until it's paid in full
Yes, ma'am.
with 0% interest, correct?
Yes.
All right. You will have a right to petition the court. I think you have so used to doing criminal law. I think it's 10 days. Is it 10 days or 3 days, Mr. Beers?
I think it's 3 days.
All right, you'll have 3 days to petition the court to set it aside for a good reason, considering that it's a consent judgment and you don't have counsel. So you should probably reach out to counsels as quickly as possible to make sure that you are okay with this agreement, okay?
Okay. Thank you.
And the motion for summary disposition is withdrawn, is that correct?
Correct.
All right, thank you. You're all set. How soon can you get the order over to me, Mr. Beers?
I've got another hearing at 3 o'clock in front of you, so it will probably be tomorrow.
Okay. Then what I'll do is I'll put this, ooh, that's a long way away. Well, it should be plenty of time. I'll put this on the docket for April 3rd, 2025 at 3 p.m. For entry of order. Okay, so if the order's not here by then you need to be here, which is, I think, what you hear from me this afternoon on as well, entry of order issue. All right, thank you. You're all set.
Thank you.
Thank you.